You're driving home. Red and blue lights flash behind you. The officer walks up and says, "Mind if I take a quick look in your trunk?" Most people say yes, thinking they have to. But there are 5 things cops absolutely cannot do during a traffic stop. If you don't know them, you could lose your freedom, your money, and your rights. I've analyzed over 300 traffic stop cases and Supreme Court rulings. In the next 20 minutes, I'll show you the 5 legal lines police cannot cross, the exact words that protect you, and the case law behind it. This isn't about being difficult. This is about knowing your constitutional rights. Let's jump in. Thing number 1. They cannot search your vehicle without consent, probable cause, or a warrant. This is the most violated constitutional protection in America. Picture this. You get pulled over for a broken taillight. The officer says, "You don't mind if I take a quick look around, do you?" That question is designed to make you give up your Fourth Amendment protection. When you say yes, you've waived your strongest legal shield. The officer can now search your entire vehicle. Glove box, trunk, under seats, every bag. And if they find anything, even something you didn't know was there, you're responsible. Here's the wrong way. Officer: "Can I search your vehicle?" Driver: "I guess so. I don't have anything illegal." Officer: "Great. Step out." 10 minutes later, the officer finds a bag of marijuana under the passenger seat left by a friend last week. You didn't know it was there. Doesn't matter. You consented. You're getting charged. Your attorney has zero defense because you voluntarily gave permission. Now the right way. Officer: "Can I search your vehicle?" Driver: "Officer, I do not consent to any searches." Officer: "Why not? You hiding something?" Driver: "I'm exercising my Fourth Amendment rights. Am I free to leave?" If the officer searches anyway without probable cause, your attorney files a motion to suppress. The evidence gets thrown out because the search violated your constitutional rights. Why do people consent? They think refusing sounds suspicious, but legally, your refusal cannot be used as probable cause. That's from the Supreme Court. Refusal is your right, not evidence of wrongdoing. Now, probable cause is different. If the officer sees contraband in plain view, smells marijuana, or observes drug paraphernalia, that creates probable cause to search without consent. But they need that evidence before they search, not after. Here's the exact response. Look the officer in the eye and say, "Officer, I do not consent to any searches." Don't explain. Don't justify. Just state it clearly. This creates a record on body cam. If they search anyway, your attorney can file a suppression motion arguing the search violated your Fourth Amendment rights. One client refused consent 5 times on camera. The officer searched anyway. We filed a motion. Case dismissed. That video saved him. Bottom line: never consent to searches. Say the words clearly, then stay silent. That protects your Fourth Amendment right against unreasonable searches. But even if you refuse consent, officers still try to extend the stop using other tactics. Thing number 2 is where the Supreme Court drew a clear line that most officers hope you never learn about. Thing number 2: they cannot prolong the stop beyond its original mission without reasonable suspicion. This comes from Rodriguez versus United States, a 2015 Supreme Court ruling. The court said traffic stops have a mission: write the ticket, check your license, verify registration and insurance. Once complete, the stop must end. Officers cannot extend it, even minutes, to fish for other crimes without independent reasonable suspicion. In Rodriguez, the officer kept the driver 7 to 8 extra minutes waiting for a drug dog. Dog alerted. They found methamphetamine. The Supreme Court ruled the prolonged detention violated the Fourth Amendment. Justice Ginsburg wrote that stops prolonged beyond the time reasonably required to complete the mission are unconstitutional seizures. 7 minutes was enough to violate rights. Here's how this escalates. Wrong way. Officer hands you the warning. Officer, sit tight for a minute. You sit. 20 minutes pass. K9 arrives. Dogs sniff. If they find something, you never created a record that you wanted to leave. Courts assume you consented to wait. Right way? Officer hands you the warning. You immediately ask, Officer, am I free to leave? Officer, hold on. You, I understand, but the traffic stop appears complete. Am I being detained? Officer, yes. You, what is the reasonable suspicion for continued detention beyond the traffic violation? He can't provide specific facts. Now you've documented an unlawful detention. Anything found after that point faces suppression in court. So when the officer finishes but keeps you waiting, ask clearly, Officer, am I free to leave? If yes, drive away. If no, ask, am I being detained, and what is the reasonable suspicion? Those questions force accountability. Without specific facts, the detention becomes unlawful. Nervousness alone doesn't justify it. Refusing consent doesn't justify it. Being in a high crime area doesn't justify it. Courts have ruled on all of these. Bottom line, once the mission is complete, they cannot hold you without separate justification. Rodriguez protects against prolonged detention, but the Fourth Amendment also controls when officers can physically remove you from your vehicle. Thing number 3 addresses a case everyone cites, but most people misunderstand. Thing number 3, they cannot order you out without a lawful traffic stop. Pennsylvania versus Mims says officers can order you out during a lawful stop for safety, but the stop itself must be lawful first. If the initial stop violates the Fourth Amendment, nothing that follows is legal. In Mims, officers pulled over a car for an expired license plate, a valid violation. The stop was lawful, so ordering the driver out was permissible. But if an officer pulls you over without reasonable suspicion, that's illegal. A stop based on a hunch or because you looked suspicious isn't lawful. Here's a scenario. You're driving perfectly legally at night. No violations. Officer pulls you over. You ask, Officer, why was I stopped? He says, just a random check. That's not a lawful stop. Random checks violate the Fourth Amendment. If he then orders you out and discovers something during a pat-down, that evidence flows from an illegal seizure. Your attorney can get it suppressed. During a lawful stop, officers can order you out under Mims, and you must comply. Refusing leads to obstruction charges, but create a record first. Wrong way, officer. Step out of the car. You. Why? I don't have to. Officer, you're resisting. Now you're getting arrested for obstruction during what might have been a lawful order. Right way, officer. Step out. You. Officer, are you asking or ordering me? Officer, I'm ordering you. You. For the record, I'm complying under protest to avoid obstruction. What is the lawful reason for this order? You step out calmly. Now you've documented everything while obeying the law. Mims doesn't allow a full search without separate reasonable suspicion you're armed. It doesn't allow searching your car just because you're outside. It doesn't permit indefinite detention. Mims is narrow. Officers can order you out for safety during a valid stop. Bottom line, officers can order you out during lawful stops. But if the stop wasn't lawful, nothing that follows is valid. Mims addresses when officers can order you out, but ordering you out and placing you under arrest are different legal standards. Thing number 4 is where the Fourth Amendment draws its brightest line. Thing number 4, they cannot arrest you without probable cause. Probable cause means facts that would lead a reasonable person to believe you committed a crime. Not a hunch. Real evidence. Minor traffic violations usually don't justify custodial arrest. Officers write citations, and you leave. But some escalate, hoping to search incident to arrest. Atwater versus City of Lago Vista addressed this. A driver wasn't wearing a seatbelt. The officer arrested, handcuffed, and jailed her. She sued. The court said the arrest was lawful because probable cause existed even for a fine-only misdemeanor. Officers have discretion, but they still need probable cause. Direct observation of a crime, corroborated tips, evidence in plain view create probable cause. But nervousness? Not probable cause. Refusing questions or searches? Not probable cause. Courts made this clear. Exercising rights isn't evidence of guilt. Wrong way example, officer pulls you over for speeding, asks where you're going. You say nothing. Officer says, "You're acting suspicious, step out." You comply nervously. Officer says, "You're under arrest for obstruction." That's an unlawful arrest. You didn't obstruct anything. Your silence is protected by the Fifth Amendment. Right way? Officer asks where you're going. You say, "Officer, I'm invoking my right to remain silent." Officer says, "You're being difficult." You say calmly, "I'm exercising my constitutional rights. Am I free to leave?" If he arrests you for this, that arrest lacks probable cause, and any evidence obtained gets suppressed as fruit of the poisonous tree. If an officer arrests you, don't resist. Stay calm. Say clearly, "I do not consent to this arrest. I invoke my right to remain silent and my right to an attorney." Then stop talking. Resisting even an unlawful arrest creates another charge harder to beat. Bottom line. Arrests require probable cause. Without it, the arrest is unlawful, and everything following can be challenged. Unlawful arrests violate Fourth Amendment protections, but even during lawful stops, there's one tactic officers use that makes drivers think their refusal will be used against them. Thing number 5 destroys that myth. Thing number 5. They cannot use your refusal to consent as probable cause. Refusing to consent to a search is not probable cause. Refusing to answer questions is not reasonable suspicion. Your silence cannot legally be used as evidence of guilt. The Supreme Court ruled on this repeatedly, but officers use it as psychological pressure. Officer asks, "Mind if I search?" You say, "I do not consent." Officer's face changes. "Really? Why not? What are you hiding?" Don't fall for it. Schneckloth versus Bastamonte established consent must be voluntary. Refusing is exercising your constitutional right, not evidence of wrongdoing. Florida versus Bostick confirmed this. Refusal alone doesn't create reasonable suspicion. So when the officer says, "What are you hiding?" you don't owe an explanation. Repeat, "I do not consent to searches." If he keeps pushing, add, "Officer, I'm exercising my Fourth Amendment rights. Am I free to leave?" Here's a full dialogue showing the wrong way versus the right way. Wrong way. Officer, "Can I search your car?" Driver, "Well, I don't really want you to, but I guess if you need to." Officer, "Great." He searches. Finds something. You consented. No defense. Right way. Officer, "I need to search your vehicle." Driver, "Officer, I do not consent to any searches." Officer, "Why not? You hiding something?" Driver, "I'm exercising my Fourth Amendment rights. Am I free to leave?" Officer, "No, I'm calling a K-9. You'll be here a while." Driver, "I do not consent to prolonged detention. Am I being detained? And if so, what is the reasonable suspicion for continued detention?" Officer can't articulate specific facts. Driver has now documented an unconstitutional detention. Everything found after can be suppressed. Here's the bluff. If you won't consent, I'll get a warrant. If they had evidence for a warrant, they would have gotten one already. Warrants require probable cause, a sworn affidavit, and a judge's signature. If the officer is asking your consent, he doesn't have enough. Stay calm. Say, If you have probable cause for a warrant, pursue that. But I do not consent. The K9 threat. I'm calling a dog. Remember Rodriguez. They cannot prolong the stop to wait for a dog without reasonable suspicion. Respond. Officer, am I free to leave or being detained? If detained, what's the reasonable suspicion? If he detains you without justification, that's unconstitutional. Everything after can be suppressed. Bottom line, never consent, even if you have nothing to hide. Your refusal is your legal protection. Without it, you have no defense. Here's the truth. Police officers have a job to do, and that job involves investigating crimes and gathering evidence. But you have constitutional rights that limit what they can do during a traffic stop. They cannot search without consent, probable cause, or a warrant. They cannot prolong the stop beyond its mission without reasonable suspicion. They cannot order you out without a lawful stop. They cannot arrest you without probable cause. And they cannot use your refusal to assert rights as evidence against you. Knowing these 5 limits changes everything. It separates drivers who protect themselves from drivers who give everything away without realizing it. The difference between a routine ticket and a criminal charge often comes down to knowing these limits and using your voice. Stay calm, stay respectful, but stay firm. When you assert your rights clearly and politely, you make it exponentially harder for officers to violate those rights. And if they do anyway, you create the evidence your attorney needs to fight back in court. Body cameras work both ways. Use them to your advantage by stating your rights clearly and repeatedly. So remember the 4 phrases that protect you every single time. Number 1, am I free to leave? This establishes whether you're in a consensual encounter, a detention, or under arrest. It forces the officer to justify holding you. Number 2, I plead the 5th, or I invoke my right to remain silent. This protects you from self-incrimination and stops fishing questions cold. Number 3, I want a lawyer, or I want an attorney. This ends interrogation immediately and triggers your 6th Amendment protection. Number 4, I do not consent to searches. This preserves your 4th Amendment rights and creates the foundation for suppression motions if they search anyway. Memorize them. Practice them, use them, print them out, and keep them in your glove box if you need to. These aren't just words. They're legal shields backed by Supreme Court rulings like Rodriguez versus United States, Pennsylvania versus Mims, Schneckloth versus Bustamante, and countless other cases. When you use them calmly and clearly, you make it much harder for officers to violate your rights. And if they do, you create the evidence your attorney needs to fight back in court. Here's your action step. The next time you get pulled over, stay calm, be polite. Provide your license, registration, and insurance. That's what you're legally required to do. Beyond that, assert your rights. Don't guess. Don't explain yourself. Don't talk your way into trouble trying to seem cooperative. Use the phrases. Create the record. Let the body cam capture your words clearly. And if things go wrong, if you're searched, detained, or arrested, call an attorney immediately. Your rights only matter if you're willing to defend them. This is educational content only, not legal advice. Always consult with a qualified attorney in your state for your specific situation. If you found this valuable, hit the like button to show your support. Subscribe for more insider legal strategies, and tap the bell so you never miss content that could save you time, money, or even your freedom. Share this video with friends and family. Everyone deserves to know what police cannot legally do during traffic stops. And if you want to keep building your legal knowledge, I've got additional constitutional protections and case law analysis that applies to different situations. The next video builds on what you just learned and covers how multiple rights work together during police encounters. It's on screen now. Watch it to complete your legal framework. Remember, the smartest drivers aren't the ones who talk their way out of trouble. They're the ones who know their rights and use them. always plead the fifth.